Well, hello everyone, good afternoon, and welcome to this webinar. Thank you for joining us. We're going to take you through an interesting Court of Appeal decision in a case called Denaxe against Cooper and Rubin. And of course, we would say it's interesting because we appeared in the Court of Appeal for the successful respondents. And I appeared for them at first instance before Mr. Justice Fancourt. We're going to take you through both decisions, the first instance and the Court of Appeal proceedings, and give you some thoughts on where the decision leaves as practitioners, what guidance the Court of Appeal did ultimately give when it handed down its decision at the end of June. I'd just like to thank Martin Jensen and Zoe White from Beale & Co for our instructions, and to thank our clients Paul Cooper and David Rubin for their instructions as well. And with that, I'm going to hand over to Dan to talk through the legal and factual context.
Thank you very much, David. Right, hopefully you can see the slides. So today we've got two cases which relate to the sale of Blackpool Football Club. You see, we've got the first instance decision, Denaxe and Cooper, which was handed down by Mr. Justice Fancourt in April 2022. And then we've got the recent Court of Appeal judgment, which is fairly fresh, having been handed down on the 30th of June 2023. So before I get into the facts and the sort of factual context to all of this, a couple of brief legal refreshers, if I may. There's two here. The first relates to the appointment of receivers by way of equitable execution. Now, this is a method of enforcement of a judgment debt, and there's an express power now of appointment by the court under section 37(4) of the Senior Courts Act 1981. And receivers appointed by way of equitable execution are officers of the court. There's some helpful guidance in a commercial court decision, City 1, Mauritius Holdings and Unisec Limited from 2014. And that really explains that the jurisdiction will not be exercised unless there's some hindrance or difficulty in using the normal process of execution. And indeed, certainly not if the appointment would be fruitless. So the second legal context, and really what this webinar is about and these two cases are about, is the jurisdiction to bless, approve or sanction a so-called momentous decision. Now, private client practitioners will be familiar with the public trustee in Cooper case and the court's inherent jurisdiction over the supervision of trusts. And in that case, what we private client lawyers call the type 2 case is the so-called blessing of the momentous decision. And quite a good example is in the Earl of Cardigan case, Cotton and Brudenell-Bruce, which went up to the Court of Appeal. In the sort of bridging case between trustees and office holders was one of the MF Global decisions in 2014. I believe that was David Richards. And in that context, we had office holders acting as trustees who utilised the inherent jurisdiction. Now, in recent years, we've seen a sort of leapfrog or a transposition of the public trustee and Cooper type applications in relation to office holders. And the relevant provision is in paragraph 63 of Schedule B1 of the Insolvency Act 1986 that contains a provision essentially for office holders to ask for directions. And the seminal case really in this area was the decision of Mr. Justice Snowden, as he then once was in Re Nortel. That was 2016. That related to administrators and essentially the blessing of a momentous decision. In that case, it was a compromise by administrators. Recently, there's been a couple of these involving administrators. The case of Re Petropavlovsk, which was a decision of Jonathan Hilliard KC, and very recently, Re Sova Capital, which is an excellent judgment by Mr. Justice Miles. And that came out after our Court of Appeal hearing, but prior to the judgment, and it was very properly brought to court's attention by our opponents. In relation to receivers by way of equitable execution, well, it was actually these proceedings at first instance where Mr. Justice Fancourt held that the same jurisdiction applied in relation to receivers. So that's the sort of legal context. The key question really, and what we're seeking to address and what the Court of Appeal sought to address is, what does the so-called immunity, what immunity does the blessing create? So that's legal context. Let me just give you some factual context to these proceedings because they were a little bit complicated. As I said, they're about the sale of Blackpool Football Club. Now, the company in these proceedings, Denaxe Ltd, used to be called, it was formerly called Blackpool Football Club Properties Limited. And the company owned just over 75% of the shares in Blackpool Football Club Limited, as well as Blackpool Football Club Stadium at Bloomfield Road. Now, there arose a dispute between Denaxe, which was controlled by Owen Oyston, the long-time owner of the club, and another shareholder in the form of VB Football Assets. And that was controlled by a Latvian businessman, Valery Belakon, and VB Football Assets owned about 20%. There was an unfair prejudice petition, and that was heard by Marcus Smith J. And in 2017, he ordered both Denaxe and Mr. Oyston to buy out Mr. Belakon's shares for over £31 million. Enforcement proved problematic and there was a hindrance. And so Paul Cooper and David Rubin, our lay clients, successfully were appointed as receivers by equitable execution. And that really begins the story of these proceedings. So the receivers were tasked with realising the judgment debt, which involved selling assets. That's what these receivers do, including so-called footballing assets. Now, the receivers conducted an extensive marketing campaign to try and generate bidders. It was deemed not possible to sell the footballing assets without including both of the large shareholders in Denaxe. Any buyer wanted all of the two shareholders. There was about 3% left, but it was thought that with the Oyston shareholding and the VB shareholding, that would be sufficient to sell the club. That was proved correct. Now, the view was taken that the best deal was a sale of both shareholdings in one transaction to a specific bidder at a specific price. And so VBFA applied to court to vary the buyout order, but the receivers at the same time applied for approval under this jurisdiction in Public Trustee and Cooper to sell in a single transaction. So the matter came back before Marcus Smith J, and the court varied the buyout order and approved the proposed transaction. And the judgment, which was turned around very quickly by Marcus Smith, is in 2019 EWCA 1599. Now, importantly, Mr. Oyston was represented at the hearing and had filed evidence, though he sought to reserve his position on the sale. And Marcus Smith J criticised Mr. Oyston's position as being remarkably unsatisfactory. The other important thing to note is that Denaxe, the company here, was controlled by independent non-Oyston, as it were, directors. The company was served but didn't take part. So the key point here is that the privies, as the Court of Appeal later call it, being Mr. Oyston, did take part in the hearing. After the so-called sanction application, in short, Denaxe turned around and issued professional negligence proceedings against the receivers, seeking damages of just over £86 million. The initial complaint was that there'd been a sale of the shares and other assets at a significant undervalue. Importantly, by the time of the hearing of these proceedings, which were the receiver's strikeout application, the company had essentially abandoned its claim that the shares in the club had any value at all. They said they were toxic. But instead, they focused on the allegation that the other assets should have been sold separately. So there should have been a breakup of the footballing assets in order to maximize value. And it was stated in amended particulars of claim that the value of damages sought were £26.5 million. So that's the factual background. I'm going to hand over to David to talk about the first instance decision of Mr. Justice Fancourt.
In front of Mr. Justice Fancourt, I've been let out on my own at this point without Dan to keep me on the straight and narrow. We made an application for the summary disposal of the claim against the receivers. And we, you might say we threw the kitchen sink at that, in that we put it on 4 bases, and they're the ones on your screen. The first one, we call the immunity basis. The receivers were immune from the claim against them. They were immune from suit because the very sale that was being criticised in the claim had already been sanctioned or blessed by Mr. Justice Marcus Smith a few days before it took place. And therefore we said the claim was abusive and ought to be struck out. We also ran a Henderson abuse argument that the claimant company, and bear in mind the claimant company had been served and chosen not to take part, that it could and should have raised the issue that it was now seeking to raise in the negligence proceedings back in front of Marcus Smith J at the hearing of the sanction application. And that therefore, by the application of what used to be called Henderson and Henderson abuse, by the application of that principle, the claim was precluded and ought to be struck out. Now, we ran a third abuse type argument, which was that the decision to sanction gave rise to an issue of estoppel, and that therefore the claim now brought was res judicata and abusive. And finally, we applied for what's called reverse summary judgment, which is an application by a defendant, which we were, saying that the claim had no reasonable prospect of success and ought to be summarily disposed of. And we ran that for a day and a half in front of Mr. Justice Fancourt in Manchester. Denaxe resisted the application on each of the bases. On the immunity ground, what the company said was that it wasn't running a claim for breach of equitable duty. It accepted that a breach of equitable duty could not be brought and the receivers were immune from that. But what they weren't immune from was a claim for breach of common law duty. And that's what their claim was. It was a negligence claim, and therefore the sanction was irrelevant and they weren't prevented from bringing their claim for sale at undervalue. On the Henderson and Henderson point, and this really became the focus of quite a lot of the submissions, both at first instance and in the Court of Appeal, nobody had been obliged to raise what had become the common law negligence claim in front of Marcus Smith J, and therefore there was no abuse. It said very shortly in respect to the res judicata point, well, that actually was a non-starter. There'd been no decision, and therefore there was no issue of estoppel. And on the merits, the company said, well, we get over that very low threshold, and we have reasonable prospects of success. The hearing, as I say, was in a day and a half, 8th and 9th of March 2022, and it was a quick judgment, 6th of April, Mr. Justice Fancourt, 123 paragraphs, looking at all the points that we'd raised and argued in front of him. He struck out the claim on two of the bases that we'd raised. First, he said, the receivers are immune from breach of duty in respect of the particular sale, whether that duty was equitable or a common law duty. And having reviewed the authorities, and in particular the decision of Mr. Justice Snowden in Nortel, he said that decision was not limited to claims only for breach of fiduciary duty, and therefore immunity attached. He also said in paragraphs 80 and 84 of his judgment, that the fact and extent of immunity derives in principle from two matters: the nature of the review conducted and the decision that actually was approved, and whether immunity extends to the claim then brought, the negligence claim after the event. Whether immunity extends to it, that depends on what allegations are made or necessarily involved in the claim. And he went on at paragraph 84 to say, for a subsequent claim to be precluded by immunity, the wrong alleged against the office holder must be one relating to the decision-making process or the aspects of the transaction that the court has sanctioned. So we're back to the particular transaction question. He went on to say, if the breach alleged relates to an unconnected decision or other conduct of the office holder, there would be no immunity. However, he also said, in any event, that the claim was the clearest possible Henderson and Henderson abuse of process. And looking at that, it's worth recalling that the claimant, Denaxe, had been served but chosen not to take part. Mr. Royston had been given an opportunity to take part. The directions for the hearing of the sanction application had been fashioned so that he could take part. And he had at that time available to him the alternative evidence upon which he based his argument in the negligence proceedings that what the receivers should have done is sold the assets separately. And therefore he could have raised the point in front of Mr. Justice Marcus Smith. Now, if he had done that, it was likely that there would have been no sanction. Now, that wouldn't have prevented the sale from taking place, because as you'll know, on one of these applications, there is no surrender of the office holders or the trustees' discretion. They make the decision themselves and retain that decision-making power. But in the real world, if they come along for sanction and don't get it, they're very unlikely then to go on and carry into effect the transaction in question. So if there'd been no sanction, likely there would have been no sale. And if no sale, then likely no loss or suffered as alleged in the negligence proceedings. And therefore, Denaxe should have raised the point at the sanction hearing in front of Mr. Justice Marcus Smith. And that, I suppose, even more so applied when Mr. Royston was looked at as the person who'd been given the express opportunity to come along and argue the point. And Mr. Justice Fancourt described him as having taken a calculated decision not to do so, and that rendered the claim a Henderson and Henderson abusive process. So that's where we got to at first instance, and Dan's going to take you through the grounds of appeal.
Right, thank you. Grounds of appeal. So Denaxe obtained permission to appeal from Lord Justice Snowdon, who of course had given the judgment in Nortel and was plainly interested in this jurisdiction. And it was stated that the Court of Appeal wished to give some guidance on it. Now, the grounds on which Denaxe were given permission to appeal were thus. The immunity essentially applied only to a claim of equitable duty, so running the same point they were running at first instance. And in relation to the abusive process, well, in a way it was quite neat, because Denaxe was not bound to raise the issue of the claim at the hearing, because the scope of the application was limited to exercising a narrow jurisdiction, and it was equitable only. So if they were right on it being equitable only, then they said that they were right not to raise it. We thought about this and decided to resist the appeal for the reasons that Mr. Justice Fancourt gave, but we put forward an additional ground, which we called the duty ground. Importantly for these proceedings, there was a duty to take reasonable care to obtain the best price reasonably obtainable. And that went as far back as the Telson Electric case from 1936. Practitioners will be familiar with Downsview nominees, which was the debenture holders, and also cases of LPA receivers in Sylvan properties. And so what we said was that the imposition of a common law duty of care by the courts is only appropriate where there's perceived to be a lacuna in the law. And there's lots of good old House of Lords authority on that, for example, the Anns and Merton Borough case. Looking at the cases that had dealt with this, they were rather few and far between, but there was a case, the Hoogstraten case in 1985, which involved sequestrators. And in that case, Lord Justice Dillon said that a common law duty of care was owed by sequestrators. And so there was a further case called Clark and Heathfield, where it was an obiter remark by the same Lord Justice, who said, well, the position must be the same with receivers by way of equitable execution. Whereas we say that that was per incuram. It was wrong, because receivers by way of equitable execution owed a concurrent duty in equity, and there was no need to create a common law duty of care at all. So this was our argument. If we were wrong on the extent of the immunity, we said actually the receivers didn't in fact owe the legal duties which were the subject matter of the claim. So I'm going to hand back to David now to deal with the decision of the Court of Appeal.
Thanks, Dan. Having given permission for the appeal, on the 22nd of February, we had a day in front of a panel at the Court of Appeal made up of Lady Justice Asplin, Lord Justice Snowdon, and Lady Justice Falk. They gave judgment on the 30th of June, so a little while after the hearing. And unanimously, they dismissed the appeal. The main judgment was given by Lord Justice Snowdon. There was a one paragraph, I agree, judgment from Lady Justice Falk, and a short supporting judgment of 3 paragraphs from Lady Justice Asplin. In summary, by way of headline, the Court of Appeal did not decide the immunity ground. It did not decide the duty ground. It decided it didn't need to. It did decide the abuse ground, and it decided that in our favour, in favour of the receivers, and said that Mr. Justice Fancourt had been right to strike out the claim as an abusive process. It did, however, set out some reasoning on the immunity ground and got quite a lot of reasoning, quite a lot of discussion before it decided that it didn't need to decide the immunity ground. But there we are. It was uncontroversial that there was a jurisdiction to bless or sanction an exercise of power by an office holder, by which they meant an administrator or a receiver, as well as by a trustee, and they pointed to the Nortel decision for that. And what they said then was, or what Lord Justice Snowden then said was, there's no such thing as this immunity that you've all been talking about. And what there is in fact is that's in fact a judicial shorthand for the bar on subsequent proceedings that results from an issue of stop. The question of the immunity which attaches to an approval decision, so the key question that we put in red earlier on, what immunity comes from a blessing, does not permit a one-size-fits-all answer, and it is fact-sensitive depending on the nature of the question that is asked of the court on the sanction application. And the Court of Appeal approved the decision of Mr. Justice Miles in Re Sover Capital. And that's the start, really, of the guidance that the Court of Appeal decided to give. When it went on to look at this case, what it said was, on the immunity ground, that Denaxe was wrong in its submissions to seek to distinguish between common law and equitable claims. The juridical basis is an irrelevance, because the relevant question is what was actually decided on the sanction or blessing application, which then in turn requires you to think about what you're asking the court. We'll come on to look at practical points in a little while. Having set them out, the submissions on both sides, the Court of Appeal described them as powerful competing submissions as to whether or not the transaction in question here, implicitly included a decision to sell the club as a going concern. But ultimately, the Court of Appeal said, we don't need to decide that. We don't need to decide this case on the immunity ground. It went on to make an observation, a critical observation, I think it's fair to say, that much of the difficulty that had been encountered in this case would have been avoided if Mr. Justice Marcus Smith had been invited to give more detailed consideration to the question of the consequences of the approval he was being asked to give. I think it's also fair to observe that Lord Justice Snowden was similarly critical of his own approach in the Nortel Networks decision. And the criticism of what went on the sanction application in front of Marcus Smith, Jay, is perhaps unfounded to this, in this sense, that it was a perfectly reasonable application to make. The case was urgent, things were moving quickly, a sale was available, there was pressure of time because of the state that the point the football season had reached, need for cash, Mr. Justice Marcus Smith expressly said he wasn't deciding the question of immunity. To some extent, that criticism is unfair, so it seems to me. And of course, the Court of Appeal had the benefit of poring over in some detail across a full day's hearing years after the event what had gone on. But that is again a hint at the guidance that the Court of Appeal decided to give, which was most clearly, in my view, spelled out by Lady Justice Asplin in her 3 paragraphs. And on this slide and the next one, we've put it up in terms because it's worth just pausing to have a look. I don't know whether you can all see it clearly, but just to go through it reasonably quickly. She says that the protection that follows must depend on the nature of the approval sought, the issues which the court is required to consider, and who was there. So what you've got to do when you're looking at obtaining this sort of sanction, or you're looking after the event at sanction that's already been obtained, requires us to take into account the issues decided on that approval application, who was there, what their interest was, and someone who was there will not be allowed to raise the same issues later on. And that's why you get everybody you can before the court to make sure that you've covered off all the various competing interests that might exist. And she went on in her final paragraph, 171, to say, one size does not fit all. There's a wide spectrum of applications. Inevitably, the factual background will be different. And then she said this: it follows that the nature of any immunity which may arise is highly fact sensitive and must be considered with some care. No single answer to the question whether subsequent proceedings will be barred. So there is some guidance there given. We'll come back to what it means in practical terms. But the court decided it did not need to resolve this appeal on the immunity ground. Equally, it decided not to decide it on the duty ground. So the point we'd raised on our respondents' notice, that actually we only owed equitable duties, and therefore if the appellate company was right in what it said, that there was immunity from in respect to the claim for breach of equitable duties, then we'd have that immunity, thanks very much. The court said it wasn't necessary to get into that because as I've said, the juridical origins of the duty were irrelevant. But what it did decide was that the abuse ground that Denaxe were raising, that there was no abuse in a Henderson and Henderson point, was bad. And that Mr. Justice Fancourt was right to hold that Denaxe could and should have raised the issue at the sanction hearing, and that therefore the claim was the clearest possible Henderson and Henderson abuse. Accordingly, Mr. Justice Fancourt's decision stands. The claim is struck out, and that's where we get to after the judgment of the Court of Appeal. Dan.
Thanks, David. Right, impact and relevance. Well, this is the first case really to deal in detail with the consequences of so-called blessing or sanction applications. Other cases have sort of touched on it. Some judges have said they're not going to deal with it. Others have given a sort of little press here of what they think. But here actually is the Court of Appeal looking at this issue. The Court of Appeal said it was going to give guidance for applications and trustees by trustees and office holders. It has given some guidance. However, that guidance is necessarily broad brush. And the two real key points for me that come out of this decision is that any application being made, one, the court should be invited to determine the scope of immunity. That's very clear from the guidance. And secondly, it's vital to make sure the correct parties are served, because if you haven't served the correct parties, then the immunity isn't going to be conferred. This is quite difficult in practice. This particular case, the question of the extent of the immunity was so difficult and the competing submission so powerful, according to the Court of Appeal, that it actually didn't decide it. And so it really gives an example of how these cases and these sorts of applications can be very difficult indeed. Well, in practical terms, it's a judgment call. And there's a risk, really, if one goes too wide, the court might refuse to deal with it. But if one goes too narrowly, the immunity might be insufficient. The other difficult thing is trying to predict what any given judge is going to do when facing one of these applications. For example, at first instance in the Earl of Cardigan case, there were reams and reams of evidence in that case, and the judge very dutifully went through all of them. That was rather unusual, because a lot of public trustee Cooper applications relate to whether or not the trustees have the power and whether it's a rational exercise, and don't really delve. And I anticipate that there's going to be some judges who will want to deal with these sorts of applications in great detail and others who won't. And it would be incredibly embarrassing for an expensive application to be made, but to be refused by a judge who simply doesn't want to get into the detail. So that's a judgment call that is going to need to be grappled with by practitioners. We might get possible further clarification from the Supreme Court. I'm going to hand over to David on that because I think he's got some views about the way the Court of Appeal sewed up this judgment.
So the Court of Appeal refused permission to Denaxe to go to the Supreme Court. The clock's still ticking on the making an application for permission to the Supreme Court. So we're sort of watching this space on that. I mean, there isn't the decision that the Court of Appeal made is on Henderson and Henderson abuse. It's difficult to see that going to the Supreme Court. The Court of Appeal did not decide the immunity ground. I suppose if the Supreme Court is sufficiently interested in this, then it will find a way of giving permission and getting the case in front of it. I think it's a very difficult ask by Maxi, but as I say, we're waiting to see. One thing that occurred to me was how these applications, when you're looking at them in practice, will work in two different contexts, because you've got an insolvency company law type context and you've got a private client trust wills type context. And there was a meshing of these two areas of law in this case. So the principle that comes out of public trustee and Cooper has been applied by analogy into the insolvency context or the receivership context. Different judges in different jurisdictions are used to dealing with things differently. And so the attitude you might get from the Chancery Master dealing with the trust law case might be different from the ICC judge or the High Court judge in the business, the company insolvency list, dealing with this sort of application for directions by an administrator. There's a risk, it seems to me, of a divergence of approach in those two different areas. But these applications are, by definition, quick. There's usually an urgency about them. You don't have that long to prepare them. They need to get on and be dealt with so that the transaction in question can take place. And that's particularly the case in the insolvency and corporate context. You're not really, I don't think, going to go in front of the court and have a directions hearing to try and flush out early on who ought to be there, what the issues ought to be, and how that sort of case management approach. It's conceptually possible, but somebody's got to pay for it all. It's going to take time. I don't know, Dan, whether that's more likely in a private client type context. I find it slightly unlikely in an insolvency corporate context if there's a pressing need to get a sale away.
Yeah, I mean, certainly my experience of public trustee Cooper applications in Chancery Division is that there certainly were directions orders. It's very important to make sure that the procedures in place, where there's representation orders, everyone has been served. So there is usually an initial appointment before the master, and then these types of applications these days are usually heard by the Chancery Masters. But again, the extent to which a master or a judge is going to want to be given chapter and verse and really do a deep dive is going to be up to that individual judge. Because if the judge takes a view or the master takes a view, well, I'm only really looking to see whether the power exists and whether the exercise of that power is rational. That's your classic sort of private client look at it. What's interesting about the office holder context is you're looking really at commercial decisions. You're looking at people who are being paid to do their job, to sell an asset at the best price reasonably obtainable. To what extent is the court going to entertain these sorts of applications, which in a way seek to sew up or sort of guarantee or prevent any claims? I mean, they're obviously a very powerful tool for professional office holders. I mean, an example given during our Court of Appeal hearing is whatever learned tax leading counsel writes a very difficult opinion and pops down to the master the next day to get the opinion ratified. And this was used as an example to how the jurisdiction could really escape. And I think there was a certain element of considering whether the genie needs to be put back in the bottle. And I do wonder whether if the Supreme Court ever looks at this, actually scrutinising the jurisdiction and to what extent is it Is it under the Insolvency Act 1986 given directions, or is that just a procedural element? Is this under the court's inherent jurisdiction to supervise the administration of companies? There are potential questions there that I think need to be answered in due course, and we'll see in the next couple of years how the courts view these. And it was interesting for people to write up insofar as they can case notes and give some sort of examples for people to look at in the sort of day-to-day lists of how these applications are being dealt with in the office holder side.
Yeah, I should have said, and apologies if I didn't, the Q&A is open. If anyone wants to type any questions into that, we'll have that open. We can see any questions that you've got. Please do put them in there. A couple of other points that occur to me, certainly in the office holder context. We know from T&D Industries that the court's not a bomb shelter. Whilst you can go and ask for sanction or blessing, it's for momentous applications. But the court's not going to just hand out blessing orders all over the place, because as Dan observes already, the professional office holder is there for a commercial reason. They're insured. They have to make these difficult decisions, and they are best placed to do so. So I think it's got to be truly momentous before you could persuade the court that actually ought to entertain the application, certainly in the office holder context. And then just one observation, I think, on the sort of trustee type context. I think there may well be a difference of attitude towards a family trustee who's not remunerated, and a professional trustee who is, and also likely to be insured and all the rest of it. And so I think that's a context that needs to be borne in mind as this is worked through, and we see how it plays through in practice.
I mean, one of the sort of quite common uses of public trustee in Cooper is where you have executors, so professional executors and trustees, who are sort of supervising and need to enter into a compromise. And there might be several different claims. You might have minor beneficiaries. You usually have unborns as well. Their charity might be in there. And actually, in order to exercise their power under the Trustee Act to compromise, they're worried about potential issues afterwards with minors and unborns. And I've certainly seen in that context the court accept that it's a momentous decision to compromise one or more different claims being made on the estate, and using it that way to try and prevent further problems later down the line. But in those circumstances, it's vitally important that everyone's properly represented. So it's not. Although it's a momentous decision, the urgency often isn't as real as in, for example, needing to sell to a specific bidder before the football club starts, a football season starts.
Yeah. Thanks very much for joining us, and have a lovely evening.
Great. Thank you very much. Good evening.